Good day, everyone. Today we will discuss Articles 62 to 69 on penalties. Now, what is the effect of the attendance of mitigating and or aggravating circumstances and of habitual delinquency? As to aggravating circumstances which are in themselves constitute a crime, such as by means of fire, which is a crime of arson by itself, or those already included in the law in defining a crime and prescribing the penalty, for example, laying of hands upon a person in authority, which is already included in defining the crime of direct assault, or those already inherent in the crime, like the aggravating circumstance of dwelling, which is inherent already in the crime of trespass to dwelling. The rule is they shall no longer be considered in imposing the penalty because in number 1 and number 2, they are already considered by the law in prescribing the penalty for the offense. And in number 3, the circumstance is already absorbed in the crime committed. So there is no more reason, so to speak, to regard them as aggravating circumstances which have the effect basically of increasing the penalty. Now, as to aggravating and mitigating circumstances which are caused by the moral attributes of the offender or his relations with the offended or any other personal cause, only the offender having such attributes shall be affected. So this applies to situations wherein there is more than one offender involved in the commission of the crime. Okay, so if there be more than one offender involved in the commission of the crime or who committed the crime, and that circumstance affects only him, then the increased penalty should only be imposed on him and not on the other offender. For example, only the minor can enjoy the privileged mitigating circumstance of minority, or habitual delinquency shall be considered against the one to whom it pertains and will not aggravate the crime of the other offender. As to modifying circumstances added by Republic Act 7659 in relation to Article 62, when advantage is taken off by the offender of his public position, the penalty shall be in its maximum period regardless of the presence of mitigating circumstances. Meaning to say, the rule in Article 64, which we'll discuss in a little while, will no longer or will not apply. So take note of this. If the person involved is a public officer and he takes advantage of his public position, it will be considered as an aggravating circumstance which has the effect of imposing upon him a penalty in its maximum period, even if he is able to prove mitigating circumstances. Or the maximum penalty shall be imposed if the offense was committed by a person who belongs to an organized or syndicated crime group. An organized or syndicated crime group is a group of two or more persons mutually helping one another for purposes of gain in the commission of any crime. Now, as to habitual delinquency, These are the effects. Upon a third conviction of the habitual delinquent shall be sentenced to the penalty for the last crime of which he was found guilty, and an additional penalty of prison correctional in its medium and maximum periods. If he is convicted for the fourth time, the convict or the habitual delinquent shall be sentenced to the penalty for the last crime of which he was found guilty, and an additional penalty of prison mayor in its minimum and medium periods. So you will now notice here that the penalty increases as the number of conviction increases. Upon a fifth or additional conviction, the convict shall be sentenced to the penalty for the last crime of which he was found guilty, and an additional penalty of prison mayor in its maximum period to reclusion temporal in its minimum period. The increase in the penalty I am referring to here is the additional penalty, if you will notice. Okay? The meaning there of the phrase shall be sentenced to the penalty for the last crime, this refers to the penalty imposed by the court with respect to the crime he committed. And because he is a habitual delinquent, an additional penalty will be meted on him, which increases as the number of conviction increases, starting on his third conviction. Take note that in essence, the habitual delinquent is given an additional penalty which increases with the number of convictions starting from the third conviction, as I have already discussed earlier. But for each conviction, the total of the two penalties, meaning the penalty for the crime committed and the additional penalty, should not exceed 30 years. Another effect of habitual delinquency is that the offender cannot benefit from the retroactive application of a favorable penal law, with the sole exception of Republic Act 9346, the law which abolished the death penalty, which applies even to habitual delinquents. Now, how does a person become a habitual delinquent? A person is a habitual delinquent if within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification, he is found guilty of any of said crimes a third time or oftener. That is the definition given by the article itself. Now let us dissect in our own words what a habitual delinquent is. So these are the requisites of habitual delinquency. Number one, the offender had been convicted of any of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification. Take note of the enumeration class because any other crime not included in the enumeration will not be counted for purposes of habitual delinquency. Second requisite, within 10 years from that first conviction of any of the crimes I just mentioned, or within 10 years from his release from prison after serving sentence for that first conviction, the convict or the offender was again convicted of any of the said crimes for the second time. So it could be the first conviction is physical injuries and the second conviction is robbery, or it could be The first conviction is physical injuries and the second conviction is still for physical injuries. Of course, referring to a different incident. Third requisite, within 10 years from that second conviction or release from prison after serving sentence for that second conviction, the offender was again convicted of any of the said crimes I just enumerated for the third time or oftener. Now, if the offender commits or is convicted of any of the said crimes for the third time, this third conviction of his is the moment when he becomes a habitual delinquent. And as I have already discussed, it is on his third conviction where the additional penalty starts. Okay? Between the first and the second conviction, as well as between the second and the third conviction or release from prison, remember that the interval must be within 10 years. What does this mean? The conviction of the accused, the latest conviction of the accused, must occur within 10 years from the date of his last conviction or from the date of his last release. Either, because if his latest conviction occurs more than 10 years from the date of his last conviction or his last release, then that latest conviction or new conviction of his will no longer be counted or will not be counted for purposes of habitual delinquency. Okay? Now, the counting of the 10-year period may be reckoned either from the day the accused was convicted or from the day he was released after serving sentence. To repeat, the enumeration of the crimes is exclusive. If X, for example, was convicted of the crimes of theft, homicide, and estafa, he cannot be considered a habitual delinquent because homicide is not included in the enumeration. This is always the rule even if the third and the second convictions each occurred within the 10-year period. A habitual delinquent may previously have been a recidivist also. If you still remember our earlier discussions, a recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the revised penal code. For example, X was convicted of theft in 2013. In 2018, he was tried for the crime of robbery and was subsequently convicted the following year, 2019. Theft and robbery are crimes embraced in the same title of the RPC as crimes against property. In such a case, X becomes a recidivist, which is an aggravating circumstance under Article 14, Paragraph 9. As such aggravating circumstance, the penalty for robbery for which X was convicted will be imposed in the maximum period. Why? Because, like what I said, and like what you are reading now, if an offender is classified as a recidivist, that becomes an aggravating circumstance in itself, which makes him liable for a penalty to be imposed in the maximum period. Let's now go to the rules for the application of indivisible penalties under Article 63. Rule number 1. If a single indivisible penalty is imposed, which is reclusion perpetua, the same penalty shall be applied regardless of the presence of any mitigating or aggravating circumstance. However, the word mitigating does not include privileged mitigating circumstances, for they are always considered even against a single indivisible penalty. Now, we will learn more of these privileged mitigating circumstances when we reach Articles 68 and 69. Articles 68 and 69 refer to the privileged mitigating circumstances of minority and the incomplete justifying and incomplete exempting circumstances under Articles 11 and 12 of the Revised Penal Code. Now, privileged mitigating circumstances are first considered before the rules in Articles 63 and 64 are applied to determine the proper penalty. So, what does this mean? If a privileged mitigating circumstance has been alleged and proven, as well as other modifying circumstances, whether they be ordinary mitigating or any other aggravating circumstance, in the imposition of the proper penalty, the court must first lower the penalty imposable either to 1 or 2 degrees because of the presence of these privileged mitigating circumstances. And then it is only when the penalty is lowered will the court apply the rules in Articles 63 and 64 in the determination of the proper penalty vis-a-vis the presence of the other modifying circumstances. Example number 1. X, 17 years old and acting with discernment, killed Y with treachery. Okay? So, at first glance, you will readily determine that the crime committed by X here is murder. Even if X will be convicted of murder, which has an imposable penalty of reclusion perpetua, only the penalty of reclusion temporal, which is 1 degree lower, will be imposed on him. Why? Because of the presence of the privileged mitigating circumstance of minority. X is 17 years old, which under Article 68 authorizes the court or mandates the court even to impose a penalty 1 degree lower than the penalty prescribed for the offense, even if the penalty imposable is a single and indivisible penalty, which is reclusion perpetua. Example number 2. X killed Y with evident premeditation, treachery, and with cruelty. So, there are 3 modifying circumstances here. Now, only one qualifying circumstance, either evident premeditation or treachery, is needed to change the nature of the killing to murder, from homicide to murder. The same penalty of reclusion perpetua will be imposed regardless of the attendance of other aggravating qualifying circumstances that may have been alleged and proven. So, in this example, there are 3 aggravating circumstances alleged and proven. So, only one, as I said, only one qualifying circumstance was applied by the court. The court can either apply evident premeditation or treachery, sufficient to change the nature of the crime into murder. And murder, under Article 248, has a penalty imposable of reclusion perpetua. Now, what about the other remaining aggravating circumstances? What would be their use? Nothing. Because the penalty can no longer be increased further. And in fact, reclusion perpetua under the revised penal code is the highest penalty at present. Take note that reclusion perpetua is considered an indivisible penalty even if it has a fixed duration. Okay? Reclusion perpetua has a fixed duration of 20 years and 1 day to 40 years. It is directly higher than reclusion temporal because reclusion temporal has a duration of 12 years and 1 day to 20 years. Now, 1 day sets reclusion perpetua apart from reclusion temporal. So, the duration is up to 40 years. Even if reclusion perpetua has a duration, a fixed duration of 20 years and 1 day to 40 years, it is still considered an indivisible penalty. Therefore, there is no minimum, medium, or maximum to speak of, and to which mitigating or aggravating circumstances can be applied. Because when you talk about mitigating and or aggravating circumstances, there must be a minimum, a medium, and a maximum corresponding to the penalty to which these mitigating or aggravating circumstances are applied. Also note that the indeterminate sentence law is not applied when reclusion perpetua is imposed as a single indivisible penalty. Okay? The indeterminate sentence law will be discussed in a separate video presentation. Rule number 2. With respect to the rule whenever two indivisible penalties are imposed, which is reclusion perpetua to death, this rule, take note, is no longer operative due to the abolition of the death penalty by Republic Act 9346. What do I mean by this? There were several felonies and crimes before which had an imposable penalty of reclusion perpetua to death, two indivisible penalties, because of the enactment of RA 7659, which imposed the penalty of death for certain heinous crimes. Now, because of Republic Act 9346, that penalty of reclusion perpetua to death is no longer present. Meaning to say, it has been reduced to the single indivisible penalty of reclusion perpetua only. For example, prior to RA 9346, the penalty prescribed by law for murder was reclusion perpetua to death. Now, the imposable penalty for such crime is only reclusion perpetua. Hence, Rule 1 applies. Let us now discuss the rules for the application of penalties which contain 3 periods, whether it be a single divisible penalty or composed of 3 different penalties, each one of which forms a period. So as you can see, there is a table which I have prepared, and under the left column on modifying circumstances, you can see there the different modifying circumstances in various situations. There are 5 situations there. And on the right column, or under the right column, you can see the proper periods that the courts should impose in applying the presence of these modifying circumstances. So let us deal with each of them. Circumstance number 1. Let us say the crime committed by the accused is homicide. And you already know that the penalty for homicide is reclusion temporal. And reclusion temporal contains 3 periods, a minimum, medium, and a maximum. Now, circumstance number 1, if there is no aggravating circumstance nor mitigating circumstance present in the commission of the crime, meaning to say, this refers to ordinary aggravating, ha? So if there is no ordinary aggravating nor ordinary mitigating circumstance present, then the proper period to be applied or to be imposed by the court should be reclusion temporal medium, okay, in the medium period. Now, in situation number 2, if what has been proven or what is present in the commission of the crime is one mitigating circumstance, ordinary mitigating circumstance, with no ordinary aggravating circumstance present, then the presence of that mitigating circumstance enjoins the court to impose the penalty of reclusion temporal in its minimum period. Okay? Now, in situation number 3, if what has been alleged and proven is only one aggravating circumstance, or even if there be several ordinary aggravating circumstances alleged and proven with no mitigating circumstance present, then the proper period to be imposed by the court should now be in the maximum period, which is reclusion temporal maximum. Okay, remember these 3 circumstances or situations. Now, in situation number 4, if there be present some ordinary mitigating circumstances and some ordinary aggravating circumstances, what is the rule? The rule is you should offset both ordinary mitigating circumstances and ordinary aggravating circumstances. They should cancel each other out. And whatever remains after canceling each other out, you apply the above rules. The above rules I'm referring to is rule or situation number 1, 2, and 3. So for example, in the crime of homicide, the accused was able to prove 2 ordinary mitigating circumstances, while the prosecutor was able to prove 1 ordinary aggravating circumstance. So there are present both mitigating and ordinary aggravating circumstances. You offset them. What remains is only 1 ordinary mitigating circumstance. If that is so, you apply situation number 2. And situation number 2 tells us that the court should now impose the penalty of reclusion temporal in its minimum period, because it is as if there is only 1 mitigating circumstance present with no aggravating. Now, let's go to situation number 5. If there are 2 or more ordinary mitigating circumstances present with no ordinary aggravating circumstance, then what is the rule? The court should lower the penalty by 1 degree in the proper period. For example, if the accused was able to prove 2 ordinary mitigating circumstances with no aggravating circumstance present. The effect is that the court should lower the penalty by 1 degree. What is lower by 1 degree of reclusion temporal? Diba? Prisión mayor. So, the court should now impose the penalty of prisión mayor. Now, the rule also tells us that the court should impose the proper period. And prisión mayor also has 3 periods, minimum, medium, and maximum. We have already lowered the penalty by 1 degree from reclusion temporal to prisión mayor. What is the proper period to be applied? Since there are no more mitigating nor aggravating circumstances, since we have already used up the 2 ordinary mitigating circumstances which has lowered the penalty by 1 degree, then it is as if there is no aggravating nor mitigating. Look at situation number 1. So much so that the proper period to be applied is prisión mayor in the medium period. Okay? Take note that the courts cannot lower the penalty by 1 degree when there is an aggravating circumstance, even if the net effect of the offsetting or the canceling each other out is that 2 or more mitigating circumstances are left. So for example, there are 3 ordinary mitigating circumstances and 1 aggravating circumstance. Canceling them each other out, you still have 2 ordinary mitigating circumstances left. Now, even if there are 2 ordinary mitigating circumstances left, the court cannot anymore lower the penalty by 1 degree because at the onset, there was an aggravating circumstance present. Okay? So, please take note or please remember that the court can only lower the penalty by 1 degree if there are first at least 2 ordinary mitigating circumstances with no aggravating circumstance present. The court also cannot lower by 2 degrees when there are 4 or more ordinary mitigating circumstances and no aggravating circumstances, because the law only allows 1 degree deduction no matter how many mitigating circumstances are present. So let us say there are 4 or let us say there are 10 ordinary mitigating circumstances proven by the accused during the commission of the crime with no aggravating circumstance. Does that mean that the court can lower the penalty imposable by 2 degrees or even by 3 degrees? The answer is no, because as you can see in the rule, the court cannot lower by 2 degrees even if there are 4 or more mitigating circumstances with no aggravating circumstance. The law allows only 1 degree deduction. The court also cannot impose a greater penalty than that prescribed by law no matter how many aggravating circumstances are present. So, let us go back to our previous example. Homicide, and then the penalty imposable is reclusion temporal. The penalty imposable is reclusion temporal. Now, no matter how many aggravating circumstances are alleged and proven by the fiscal, it won't increase the penalty to reclusion perpetua because that is already beyond the penalty that the law prescribes for the crime of homicide. Okay? Now, what are the instances where mitigating and aggravating circumstances are not considered in imposing a penalty? One is when the penalty is single and indivisible. We have already discussed that. Okay? Second, mitigating and aggravating circumstances have no application in felonies committed through negligence. I am talking about Article 365, no? Those crimes involving reckless imprudence. Third, mitigating and aggravating circumstances are not considered when the penalties are prescribed by special penal laws, except when the special penal laws or the special penal law concerned uses the nomenclature of the penalties in the RPC and expressly provides that mitigating or aggravating circumstances are to be considered. And mitigating and aggravating circumstances are not also considered when the penalty is only a fine imposed by an ordinance or a special penal law. Rules in cases where the penalty imposed is not composed of 3 periods. So, what we discussed previously, where the rules in cases where the penalty is composed of 3 periods. Now, we are about to discuss the rules in cases where the penalty imposed is not composed of 3 periods. Take note that Article 76 gives the legal duration of divisible penalties, meaning the rule is that it shall always be considered, all penalties imposed in the RPC shall always be considered as divided into 3 periods. So even if the penalty prescribed by law for the crime charged does not contain or is not composed of 3 periods, it shall always be considered as divided into 3 periods. It should always have a minimum, a medium, and a maximum. Now, when the law prescribes a penalty which is not composed of 3 periods, Article 65 directs that the penalty shall be made to comply therewith. How? By dividing it into 3 periods to conform to the rule that a divisible penalty shall be deemed as divided into 3 periods. Don't worry about the computation, class. Okay? You will not be asked to compute in the bar exam. Article 66, Imposition of Fines. Article 66 reads, in imposing fines, the courts may fix any amount within the limits established by law, and in fixing the amount, in each case, attention shall be given not only to the mitigating and aggravating circumstances, but more particularly to the wealth or means of the culprit. So, previously, I told you that I told you about the instances where aggravating and mitigating circumstances are not considered, and one of those is a situation where fines are imposed. But what I was talking about there, where if the fine is imposed by an ordinance or a special penal law, but with respect to fines imposed by the RPC, yes, mitigating and aggravating circumstances are to be considered. Okay? But more emphasis should be given to the wealth or means of the convict in the imposition of fines. So here, the court can fix any amount within the limits established by law. Okay? So if the fine is 200 to 1,000 pesos, if the imposable fine is from 200 to 1,000 pesos, then the court can fix any amount within that limitation, within that range. The court can fix the amount of 200 as fine, or the court can fix the maximum amount of 1,000 as fine, considering, again, the mitigating and aggravating circumstances, and more particularly the wealth and means of the convict. So there is no specific rule how the mitigating and aggravating circumstances are to be considered in the imposition of fines. The discretion lies with the court, and by express provision of Article 66, the court should give more emphasis or more consideration on the wealth or means of the convict. So if the convict is poor, then the court should accordingly impose a fine which the convict can afford as much as possible. Okay? But of course, the court can also take into consideration if there be any aggravating circumstance or mitigating circumstance. Also take note that unlike in imprisonment, fines are not divided into 3 equal portions. They are to be fixed according to the sound discretion of the court using the above guidelines. What are privileged mitigating circumstances? The privileged mitigating circumstances are found in Article 68 as amended by RA 9344 and Article 69 of the revised Penal Code. So let's start with minority as a privileged mitigating circumstance. Minority here is the minority of the accused. Okay? So if the accused was a child and he was 15 years old or below 15 years old when he committed a crime, the rule is he shall be totally exempt from criminal liability. Instead, he will be subjected to an intervention program pursuant to Republic Act 9344. Now, this is not yet the time to discuss the details of RA 9344. We will discuss that in a separate video presentation. Now, if a child was above 15, meaning to say he was already 15 years old and 1 day, but below 18, yet he did not act with discernment when he committed the crime, the rule is the same as in number 1 above. When you say he did not act with discernment, meaning the child did not act with discernment, it means that the child has no proper understanding of what is right and wrong at the time he committed the crime. And how is discernment to be ascertained? It is to be ascertained primarily by the Municipal Social Welfare Office or the City Social Welfare Office of the DSWD. There are social workers there who are trained to determine whether or not the minor acted with discernment, the capacity to determine right from wrong. Or the prosecutor in certain cases may determine whether or not the minor acted with discernment at the time he committed the crime. So if it is determined that he did not act with discernment when he committed the crime, then he will also be exempted from criminal liability. And he will also be subjected to an intervention program pursuant to RA 9344. Now, if the child was above 15, meaning 15 years old and 1 day, but below 18, and he acted with discernment when he committed the crime, this time the rule is different. He will be subjected to a diversion program under RA 9344. Now, if the child does not qualify for diversion, the criminal case shall proceed, and if the child is found guilty, then the child can now invoke the privileged or shall be entitled to the privileged mitigating circumstance of 1 degree lower than that prescribed by law. The privileged mitigating circumstance of minority, which entitles him to a penalty of 1 degree lower than that prescribed by law. Another kind or class of privileged mitigating circumstance is the presence of incomplete justifying and incomplete exempting circumstances found in Articles 11 and 12 respectively, provided majority of their conditions is present. Okay? So here, the court can, in its discretion, impose a penalty 1 or 2 degrees lower than that prescribed by law for the crime. In determining the proper penalty, the court must consider the number and nature of the conditions present or lacking. Majority of their conditions, the phrase rather, majority of their conditions means 50% plus 1. If there are 3 requisites required to justify the act or to exempt the accused from criminal liability, then a minimum of at least 2 requisites is required. However, if there are only 2 requisites required, the presence of 1 requisite is already considered as a majority. So for example, in the justifying circumstance of self-defense, if you still remember, diba, there are 3 requisites of self-defense. First, there must be unlawful aggression. Second, there must be a reasonable necessity of the means employed to prevent or repel the said aggression. And third, there should be lack of sufficient provocation on the part of the person defending himself. Now, take note that there should always be the presence of unlawful aggression, because without unlawful aggression, the 2 other requisites cannot come into play, meaning they cannot exist. So, in invoking the privileged mitigating circumstance, let's say of incomplete self-defense, it is a must that there is present the element or requisite of unlawful aggression. So, let us say the accused was only able to prove 2 requisites, unlawful aggression and lack of sufficient provocation. Since the accused was able to prove 2 out of 3 requisites, that entitles him to a privileged mitigating circumstance of incomplete self-defense, which mandates the court to lower the penalty by 1 degree. Okay? 1 or 2 degrees, depending on the discretion of the court. If the accused was able only to prove the element of unlawful aggression, what is the rule? If only less than a majority is present, diba, there are 3 requisites: self-defense, unlawful aggression, reasonable necessity, and lack of sufficient provocation. If the accused was only able to prove unlawful aggression, the same will be considered only as an ordinary mitigating circumstance that lowers the penalty only to its minimum period. That is the rule. So, let me repeat, only the element of unlawful aggression was proven. The accused in such a case is only entitled to a reduction of the penalty to its minimum. So, if the crime, let's say, committed is homicide, or the charge against the accused was homicide, and he invokes self-defense, meaning he was forced to defend himself from the unlawful aggression of the victim, but he was not able to prove the 2 other requisites, it entitles him to a penalty of, not of 1 degree lower, but a penalty of reclusion temporal minimum, as provided for in Article 13, Paragraph 1. Okay? It will be considered only as an ordinary mitigating circumstance that lowers the penalty to the minimum period pursuant to that article.